Welcome to Synergy's Subject Matter Expert Insight webinar series. This webinar is part of an ongoing series featuring Synergy's subject matter experts giving you thought leadership insights into issues that impact personal injury recoveries. During today's presentation, if you have questions, type them into the control panel where it says questions. If we don't have time for a live Q&A today, or your question isn't answered, a Synergy subject matter expert will contact you to provide answers to your questions. Before starting today's webinar, the following is a brief presentation giving you an overview of what Synergy does in 30 seconds. A trial lawyer's job isn't to know all the nuances of issues to be addressed when a case is over, to know what it takes to keep Medicaid in place or SSI, preserve Medicare and comply with the Medicare Secondary Payer Act, and resolve complicated liens that may be present when a personal injury matter is resolved. Liens like ERISA, Medicaid liens, Medicare conditional payments, MAO plan liens, FEBA liens, all of those issues are things that the trial lawyer or paralegal really doesn't have the time or relevant expert knowledge to deal with. They need an expert strategic partner that they can rely upon that can handle it without question. And that's exactly what Synergy is. It's why thousands of top personal injury firms turn to and partner with Synergy every single day.
Thank you, Jason. As indicated, I am Teresa Kenyon. I'm the Vice President of Lien Resolution Services here at Synergy, and I am here at a roundtable with some of my experts that are negotiating here at Synergy and also leading the way. So I've got Nikki, Jane, Kevin, Allison, and Jasmine, and we are going to just do a Q&A, and I'll be asking the questions and they'll be taking turns dishing out the answers. Let's go ahead and get started with a big question. Can you even negotiate a lien amount on an ERISA plan?
Yes, you can negotiate a lien with an ERISA plan, and honestly, in many cases, you should at least try. Now, whether you'll be successful depends on a few things: the facts of the case, how the plan is funded, what the language says, and how you approach the negotiation. You'll want to start by figuring out how the plan is funded. If it's a self-funded ERISA plan, then its reimbursement rights are based entirely on what's written in the plan documents. That's why it's so important to obtain those plan documents. If the language is vague or overly broad or missing key enforcement terms, you may have a strong argument to push back or even challenge the lien altogether. But even if the plan has strong language, that doesn't mean they won't negotiate. A lot of plans are open to reductions, especially if you can make a compelling case. Maybe the settlement is limited. Maybe your client has significant injuries. Maybe there were issues with liability or causation. All of that can be used to support a reduction. So yes, negotiation is absolutely on the table. It just takes a good understanding of the plan and a thoughtful strategy.
Thank you for that. So I definitely want to negotiate. If the settlement is very limited or there are lots of other liens that are big, won't they just reduce or completely waive their lien out of equity?
Yeah, so that's a great question. It's also something we see quite a bit in cases where there are multiple liens, and because some, whether usually it's due to limited insurance funds available or things like that, where the liens can certainly exceed the settlement amount by themselves, and often there's more than one and things like that. Unfortunately, a lot of these lien holders, a lot of times what they're looking at is the numbers, and it almost always will come down to what plan is, what the particular rights of a specific health plan are, and obviously the amount of money that's available for all these lien holders. With ERISA self-funded plans, particularly, and a couple other plan types, the law does not require them to take into account equitable principles. Okay, so they can avoid things like the made whole doctrine or other equitable defenses that would be available, otherwise available. So even in little settlement funds, they know they have to take a haircut, especially when there's multiple lien holders. But they don't just roll over on that argument. They want to know what everybody else is taking. A lot of times, you kind of almost have these standoffs where each lien holder wants to know what all the lien holders are accepting before they do anything. You kind of have to manage through that. It is definitely a fight, and especially when you have multiple lien holders all debating about what their rights are. It's definitely something that you have to work through because again, it's not uncommon, particularly like on a risk self-funded file, where they will demand significant amounts of the settlement. 50% is not unheard of. We hear that all the time. Or they want, I'm aware of one case where a lien holder wanted 90% of the settlement. So these things are, why we talk about equity the way I would say most people understand the word equity and what that means. Sometimes these plans will put their blinders on and they just don't have the same definition a lot of times as what your average person thinks the meaning of the word equity. A lot of times they believe that their medical damages make up the large portion of why the case was settled the way it was. And in some cases that might be partially true, but if you think about someone who has a life care plan of $3 million, that's a different story as far as what the damages were ultimately caused that limits payout that was any kind of insurance policy was available. So it's definitely something that many lien holders, depending upon their rights and everything like that, they just don't give it up. I guess to just get to get everybody paid something, they always want to fight about it.
What if the lien claim is higher than the amount that my injured client is even going to receive after attorney's fees and costs and other liens and a limited settlement?
This is a strong basis for arguing for hardship or a pro rata reduction. However, whether a plan is required to reduce their lien depends on how the plan is funded. So while a high lien amount compared to the client's net is a compelling negotiation point, the enforceability of the lien and your leverage in negotiations depends on the plan's funding status and the legal framework that applies.
So how do I know if a health plan is ERISA or not? What do I need to be looking for?
Let's start by identifying when a plan is likely governed by ERISA. The clearest sign is when it's sponsored by a private employer. That includes companies like Walmart, FedEx, law firms, or banks. If the plan is offered through an employer that is not a government agency or religious organization, then it almost certainly an ERISA plan. These types of plans are the original intent behind the ERISA law, regulating employer-sponsored group benefits in the private sector. Now let's flip the script. When is a plan not ERISA? First and foremost, government-sponsored plans are not ERISA. This includes plans from federal entities like the IRS or VA, state employer plans like the state of California or Florida, and local governments like the city of Boston or county of Travis. Second, religious organizations such as churches or church-affiliated hospitals and schools are generally exempt from ERISA. There are exceptions. And finally, if the insurance was bought directly by an individual, say from the marketplace or directly from an insurer, it's not an employer plan at all. That means it's also not covered by ERISA. The bottom line is that ERISA governs private employer-sponsored group health plans. It does not govern government plans, religious plans, or individual policies.
I'm sure it's ERISA because it's through my client's employer. So I should just pay it in full?
No, you should definitely not have the mindset that because it's ERISA, it should be paid in full. That is what the subrogation vendors want you to believe, though. After determining ERISA status, the next step is determining funding. Be aware that many subro vendors will say that a plan is ERISA, knowing that it's fully insured, but hoping that you believe it's self-funded, and also counting on you to choose to just pay it in full. The key is to obtain the policy language to see which law applies and just how much would be their maximum recovery. It often is not payment in full.
Why does it matter if the plan is self-funded or fully insured?
It matters because self-funded plans are governed by federal law, which gives them stronger subrogation and reimbursement rights. Fully insured plans follow state laws, which can limit or vary those rights. So with a self-funded plan, the medical claims are paid directly by the employer. So this means the employer takes on the financial risk, and these plans are governed by federal law. On the other hand, with a fully insured plan, that means the employer pays premiums to an insurance company who then takes on the risk of paying claims. These plans have to follow state insurance rules. Understanding whether a plan is self-funded or fully insured helps determine which rules apply and how liens should be handled. This can significantly impact how much money the plan can recover.
So with all this talk about plan funding, how is it that you determine if it's one or the other?
Obtain the plan documents and look for language describing how claims are paid and whether the employer retains financial responsibility for those claims. This indicates a self-funded plan. If an insurance company, not the employer, is responsible for payment, the plan is likely fully insured. You can also request the Form 5500, which is a filing required for most ERISA plans. You'd be looking for the Schedule A or the absence of Schedule A. The Form 5500 should be reviewed along with the plan documents to get a complete picture of the plan's funding status.
I have my client's health insurance card. Can that tell me if the plan is self-funded or fully insured so I don't even have to contact the subrogation vendor?
While the health insurance card does provide some good information, it does not reliably indicate whether a plan is self-funded or fully insured. It may provide the name of the insurance company, the third-party administrator, even some information about the employer. Many self-funded plans are administered by large insurers, which can create confusion. Ultimately, the only way to determine the funding structure with certainty is to obtain and review the plan documents.
I've heard you say in prior webinars, and I've read it on your website about the 1024B4. What does that mean again, and how can it help in the negotiation of an ERISA lien?
A 1024B request refers to a written request under the ERISA statute, which gives plan participants or beneficiaries the right to obtain copies of the plan's governing documents from the plan administrator. This can be a useful strategy in lien negotiations as it allows you to confirm the plan's funding status, assess the strength of its reimbursement claim, and identify any potential weaknesses.
So it definitely sounds like the plan documents are important, but what document should I be requesting when I'm dealing with a lien that's been asserted by a so-called ERISA plan?
When dealing with an ERISA lien, the most important step you can take is getting the right documents. Without them, you're basically negotiating in the dark. These documents are what tells us what the plan is actually entitled to and help confirm whether the lien is even valid in the first place. So here's what you want to ask for. First, the summary plan description, or SPD. So this is going to be a summary of the plan's benefits, procedures, and rules. It's meant to explain the plan in very simple terms. But this document isn't the document that legally governs the plan terms. Also, these vendors will often just send snippets of the SPD. Specifically, they'll include only the subrogation or reimbursement provision. You will want to request the entire document, not just the relevant sections. Next, you'll want to request the full plan document or the master plan document. This is by far the most important document to get. It is the legal document that outlines the official terms of the plan. It is what controls, and it does take priority over the SPD. Then you'll want to request a Form 5500. This is the annual report filed with the Department of Labor that gives some insight as to how the plan is funded. So whether it's self-funded or fully insured, that can impact how the lien is handled. And finally, request a payment ledger or lien itemization. This shows what the plan actually paid for, and you can verify whether there are any unrelated or non-injury related claims that have been included. So these documents are your foundation. They help you understand the plan's rights, confirm the lien's validity, and give you the tools to negotiate effectively.
What should I do if the subrogation vendor gives me an SPD, but not something that looks like a plan document?
It can be argued that the summary plan description is not the controlling document, particularly when its provisions are inconsistent with the statutory requirements under ERISA. Courts have consistently held that it is the formal plan document, not the SPD, that governs.
So if I know for sure that the plan is fully insured, do I even need to request the plan documents or try to get the contract language?
Yes, you absolutely should still request the plan documents and also verify with the lien holder that it is fully insured. Worst case is you believe it's fully insured and proceed accordingly, only to find out it was actually self-funded. Perhaps it just became self-funded and the prior information you had about fully insured was outdated. So always get the applicable documents. If fully insured, state law applies. That means there could be limitations to the plan's ability to recover. But the plan language may be even more limiting than the state law. Without reviewing, you may be offering more to the lien holder than the documents would even entitle them to in the first place.
Who are the common subrogation vendors and what role do they play in this whole reimbursement?
Common subrogation vendors include Rawlings, Optum, Conduit, FIA Group, and Carelon. These companies are hired by health plans, particularly large employers or third-party administrators, specifically to pursue subrogation and reimbursement claims when a plan participant receives a personal injury settlement. Many representatives of these companies are personally incentivized to recover as much money as possible. This means they are trained to push back and resist reductions or push inflated claim amounts.
So the settlement that I was able to obtain is policy limits. There was nothing more that I could have received, and my client's injuries were so much larger. How is it that this will affect the lien?
It can and often should. If the policy limits cap recovery, especially in low limit cases, you may have a strong equity-based argument. However, we regularly see subrogation vendors demand aggressive and sometimes outrageous amounts, even in limited settlement cases. It's not uncommon for plans to demand 50% or more of the total settlement, regardless of attorney's fees, costs, or the client's injuries.
My clients are never made whole, so can't I just assert the made whole doctrine in all ERISA cases and get the lien waived?
Only if the plan is fully insured or if the self-funded plan is silent or ambiguous on whether it overrides the made whole doctrine. Many self-funded plans expressly disclaim the doctrine, which can limit your ability to assert it. If the plan is fully insured, ERISA does not preempt state insurance laws, so you should review the applicable state law to determine whether the made whole doctrine is recognized and whether it applies in your case. If it does, you may have a strong basis to reduce or eliminate the lien.
Can an ERISA plan litigate for reimbursement if the funds are already dispersed to the client?
So the short and sweet answer to this is yes, they can. The fact that you dispersed by itself does not necessarily make a difference of whether the plan can still pursue its reimbursement, um, its reimbursement rights. So if we took it into the ERISA self-funded context, um, they can sue, uh, they can litigate, even though the funds have been dispersed. With the ERISA self-funded files, there's a United States Supreme Court case called Montanil. It does place limits on that, but the weight of authority, while not completely settled law, states that ERISA places no limits on the universe of possible defendants. So there are cases out there where the attorney trust account can serve as identifiable funds for the plan to recover from, and it does vary between plan types and what they can do. But for all of them, if they believe reimbursement rights, they have reimbursement rights, and those rights were ignored, they can still litigate that in most cases. So just dispersing funds, it does make it more difficult for them to recover, right? And they have to go through the process, they have to hire counsel and all the other stuff. But whether they can still pursue their reimbursement, even that money has been dispersed to the client, they can do that. And it's definitely something that is a risk. Now, there's always a question: will they over this amount or anything like that? But it definitely is a risk if you disperse a lien holder with valid reimbursement rights. If you disperse that money, they can still litigate that. There's no cutoff there. Whether they can get the money back or not, another story. Again, depending on plan type. But it is something that if you're thinking about dispersing, it is a risk that you will be taking by doing that.
The subro vendor is claiming an ERISA self-funded lien, but I'm in X state, which is a no subro, no reimbursement state. And I mostly only see plans that are subject to state law. So a good approach is to just continue avoiding the subro vendors, right?
That's risky. If a plan is truly self-funded and has clear reimbursement provisions, it can sue under federal law, even post-disbursement in some cases.
Am I, as the plaintiff's attorney, obligated to notify their health plan that I'm collecting settlement dollars?
Yes. So on this question, if you as an attorney can become a defendant in an ERISA action under 52083, yes. And the courts are a little split on this, but the weight of authority holds that the quote from the case law is ERISA places no limit on the universe of possible defendants. So one of the things that they are able to do and has occurred is, as an ERISA plan, they have to have a source of identifiable funds that they can recover from, which comes out of the Montanil case. And certain courts have allowed the attorney's trust account to serve as the source of identifiable funds, especially if they've been commingled within your trust account. So the weight of authority definitely states that the law firm itself and the attorney can be held liable for a lien that is dispersed. Now, there's a lot of factors to go into whether a particular plan would pursue that course of action, given the time and expense that it would cost them. But there are examples of attorneys who have been held liable for the lien because they've tagged the trust account as a whole. If it never got ran down to zero, is usually the analysis. Again, this is a little bit unsettled. The Supreme Court's not pronounced on the issue, but the weight of cases definitely hold that attorney can be a defendant in an ERISA action. There is actually dueling court opinions, like in particularly North Carolina, where the Eastern District Court says one thing, said no. I think it was Eastern District said yes, they can be, and the Western District said no, they can't be if the attorney had clean hands. As to whether there's a duty to notify the plan, there is, because in most ERISA plans, your client would be contractually obligated to notify the plan of any type of third-party liability settlement. Again, that is a contractual thing that really applies to the IP, but obviously can be utilized to pursue even if you have dispersed. The other issue around this is in all states that I'm aware of, an attorney has certain ethical duties as to lien holders. Are they easily discoverable? That kind of thing. Other states are not as strict about this, as the attorney has to have actual rather than constructive notice of a lien. So you would have to look to your own state's ethical rules around this issue. Most states, in my experience, kind of don't allow you to put your head in the sand. For example, I know, like Arkansas, for example, if you even suspect a person has an interest in your case, you have an obligation to notify them of the case. It doesn't mean you have to pay them what they're asking, but you do have a duty to notify. So that varies between states. So you really have to look at your own ethics rules on that. But the weight of authority, just to sum up, does hold that an attorney or the law firm itself can be a defendant in an ERISA 502A3 action, as long as there's a source of identifiable funds. So that's why you often hear ERISA plans will ask you, are you holding funds in trust? If you answer yes to that question, you just told them that they have an identifiable source that they can sue over. So just a heads up on that.
Can I use stop loss insurance as an argument against the ERISA self-funding status?
Sometimes you can use stop loss insurance as an argument against a plan being truly self-funded, but it's not always a slam dunk. So stop loss insurance, it's a policy that kicks in when a self-funded employer's costs go over a certain threshold. So technically, the employer is still paying claims up to that point, and then the stop loss carrier only steps in after that. Most courts still treat these plans as self-funded, even if the employer has shifted a large portion of the financial risk to the insurer. That being said, it is still very much worth looking into. If the stop loss deductible is unusually low, or if the plan is structured in a way that blurs the line between insured and self-funded, you might be able to argue that the plan isn't truly self-funded, or at least you could use that as leverage in the negotiation process. But generally speaking, stop loss coverage alone doesn't usually change the plan's ERISA status or strip it of federal preemption. So bottom line, it's not a silver bullet, but it's definitely something to investigate. You would want to request the stop loss contract, check the Form 5500 to see if there's a stop loss component, and see how the plan is actually structured. You may find something useful there.
So I've got a case where the subro vendor is asking for reimbursement long after I settled the case. And there's been other times where I've had subro vendors just stop responding to me because I'm asking for a reduction or I'm asking for a waiver. So how does the statute of limitations help me in these situations on these ERISA liens?
This is a question that comes up quite a bit, especially for old ERISA claims. I'm sure many of you have had the situation where you've settled and dispersed a case, and then one of the subro vendors comes in claiming an ERISA self-funded lien, 6 months after the settlement that you didn't know anything about, or is unresponsive, which sometimes occurs. Most commentators would say that the court would look to the local state breach of contract statute of limitations, because ERISA itself does not contain a statute of limitations within it. There is an argument, again, it's a minority position, that the federal catch-all could apply, which is 4 years. But again, most of these state limits are 4 to 6 years. And again, most commentators would say that the local state statute of limitations would be the application for breach of contract, because ERISA plans, at the end of the day, they are simply contracts. But like I say, question does come up a lot, especially in those older claims. One of the things I think these things come up is the subro vendors, they will go back through their data and see if they missed anything at certain times, and they do. They miss a lot. So I think this is where they're trying to send out notices and stuff. But yeah, you can definitely use a statute of limitations defense to an ERISA lien, and again, it's usually 4 to 6 years, but will depend on your state, local state determination, whatever that statute of limitations is.
Is there ever a situation where an ERISA plan loses its right to enforce its reimbursement because the funds have already been dispersed?
Yes, it is possible for an ERISA self-funded plan to lose its ability to basically enforce its lien. It's a very specific set of facts, though. So this actually comes out of a case called Montneal, a U.S. Supreme Court case, and it basically turns on the fact that health plans are limited to the remedies that were traditionally available under equity. So they cannot sue against a plan member's general assets. They have to have a source of identifiable funds or traceable funds. So if your client your client gets the money, they can and spends it on non-traceable items, either i.e. medical care, rent, food, things that aren't tangible. The plan can lose its right to sue over an issue because of that there's no source of identifiable funds. Now, obviously, there are issues with this. It's not so much a silver bullet as if the client goes out and buys annuities or a house or a car. Those are certainly traceable. And there are, as I discussed previously, there are courts that have held attorneys, particularly in firms, liable for a lien if the money was commingled within their trust account. As a source of identifiable can become the source of identifiable funds. So the answer is yes, with caveats. On this answer, one of the things it does do is highly increase the expense and time a health plan would have to go through to enforce its rights or attempt to enforce its rights. So it's definitely possible, but there are caveats to it. One of the other things that the plan can do, and at least some courts have allowed this, is offset the benefits. And what I mean by that is if a member does not reimburse a lien and goes for treatment outside of something else for something else, or even related to the accident, the plans can deny payment as long as they have the contract language to do it up into the full amount of their lien. And the Ninth Circuit most recently has endorsed that uh, as a valid action by the plan, even though that they basically held that did not conflict with the Monteil case. So it's definitely yes, but with some risks. And again, just the member or the patient would have had to spend the money, i.e., on non-traceable funds, and there has to be some reason why they would not be able to drag yourself into the case, which in a lot of cases the weight of authority says that they can. So, but this is a way, if the funds are dispersed on non-traceable items, the basic rule is the plan cannot sue, an ERISA plan cannot file under 502A3 unless it has an identifiable source of funds that says that's our money. So that is something to be aware of when you're dealing with these issues.
What should I be looking for on a claim summary to make sure that the lien is correct?
When reviewing a claim summary, don't assume it's 100% accurate. Lien holders make mistakes all the time, and when they're compiling their lien, they are including anything and everything that they deem related, whether they were told to or not. So you want to double check them. Make sure that the lien only includes treatment that's actually related to the injury. Here's what to look for. Check the dates of service. Do they make sense based on when the accident happened? I also recommend looking at the pay dates. Now, they don't always include pay dates on their lien itemizations, but they should have access to that information. If a claim was paid post-settlement, that's something that you could possibly challenge. Look for duplicate charges. It's not uncommon for the same service to show up more than once, and that lien holder representative may not have caught that. You can compare the claims to your client's EOBs. Make sure that the paid amounts match. If they don't, that's a red flag. Look out for unrelated treatment. If you see charges for unrelated injuries, body parts, or pre-existing conditions, those should be flagged. They shouldn't be a part of the lien. The lien holder shouldn't be collecting on charges that aren't tied to the underlying case. And lastly, double check the paid amounts versus the billed amounts. We often see where the billed amount and the paid amount are the exact same, indicating that that payment to that provider was paid at an unreasonable rate. I've also seen situations where the paid amount is actually higher than what was billed. Those are issues that can be raised. Digging into that claim summary can take time, but it's worth it. Catching a few errors can save your client significant amounts of money.
So the claim summary I received from the subrogation vendor includes treatment that I don't believe is related to the case I'm pursuing. Am I allowed to challenge those claims?
Absolutely. You can and should challenge any unrelated treatment or billing included in the lien amount. The lien should only include claims related to injuries sustained in your client's case. So we recommend reviewing the claim summary carefully, cross-reference it with medical records, and make sure everything on there is absolutely related. If you identify unrelated charges, you can dispute them with a lien holder, request that they adjust the total lien, and provide you with an updated claim summary.
My client does not want to pay this lien. How do I avoid liability for myself or my firm, since it's ultimately the client's choice?
So this is a very tricky question here as far as what you can do to protect yourselves. Depending upon the plan type, there might be nothing. So while it can be the client's choice and who you pay, most state level ethics rules do contain, certain obligations to lien holders, and that is something that uh, you know every state kind of has their own little take on that. But it really boils down to what your state level rules are as far as duties to lien holders. So, but all states that I'm aware of, that it's a pretty risky strategy. So like So a lot of times attorneys will try to have this, make an agreement, say, hey, I've told you about all these liens that you owe. I'm not going to be responsible for resolving them. You client understand that. And unfortunately, in a lot of plans that ERISA, that Synergy deals with, that agreement or any kind of further documentation you have with the client is not going to protect you from a claim from Medicare, Medicare Advantage, Medicaid. In most states, there's a affirmative obligation on an attorney to resolve those liens that come with their own statutory penalties, as we talked about before. So, there's, as I spoke in, even some ERISA self-funded files, there is a weight of authority that says they can, come after your trust account and those kind of things. And none of these agreements you were to make with a client are necessarily going to protect you, 100% from some type of action from a particular health plan. So in what those potential risks are is going to boil down to what type of health plan you're actually dealing with and what its rights are. And that's one thing that's so big about it, especially if you were on notice of a lien and dispersed or gave it to the client. That's going to cause that runs a risk of causing some big problems. So, the safest course of action, which nobody really wants to engage in too much, is an interpleader action. Depositing with the court and that kind of thing. Sometimes the threat alone of that will cause a lien holder to come to the table. But again, dispersing to the client without settling those liens is a risky strategy, and especially if it's a Medicaid situation, for example, it runs the risk of that individual becoming eligible for Medicaid benefits. In that kind of situation, there are penalty provisions in most of the Medicaid state statutes, in some states up into including a criminal charge for dispersing around a Medicaid lien, for example. So that's when we say the type of health plan that you're dealing with is really going to determine what your risk level is. So, like I say, this is where it's a dicey proposition to get into. I've certainly seen clients do it, but I would have to say, a lot of times when I get this question, they're referring to some type of document that they've written with the client to try to pull themselves out of it. And it's there. You just need to understand that's not going to offer you 100% protection from a plan that has that where either through statute, usually through statute, has imposed certain duties on an attorney to resolve those claims. So again, I know we probably talked about it ad nauseum in this, but it really does determine. It's determined really by what the rights of that plan are, as far as what the potential risk that could be involved in taking such a step.
So we've talked a lot about self-funded ERISA plans, but what about fully insured ERISA plans? How is it that the negotiations might differ if it's fully insured compared to a self-funded?
That's a really good question because this is an area where there's often a lot of confusion. So we've talked about ERISA self-funded plans, but there's also fully insured ERISA plans, and it's important to understand the difference, especially when it comes to negotiating these types of plans. One thing to watch for is that lien holder vendors love to throw around the word ERISA as if that's the end of the conversation. What they're hoping for is that you won't question the funding status. They're hoping that you don't ask the next question, which is the plan self-funded or is the plan fully insured? And that's really the key, because just because ERISA governs the plan doesn't automatically mean that state law wouldn't apply. It all comes down to the funding status. So with a fully insured ERISA plan, that is where the insurance company is paying the claims, not the employer. So even though the plan is still technically covered under ERISA for certain things like reporting and appeals, when it comes to subrogation and reimbursement, state law still applies. So if the state has rules that limit reimbursement, those rules still apply to fully insured plans. You'll also want to make sure that you're getting the plan documents for these plans. Even though they're subject to state law, there could still be issues that come up as it relates to the plan documents. When you're getting these plan documents, you're looking to verify, does the plan even have a valid recovery right? Some of these contracts don't even have subrogation or reimbursement provisions included in them. So you're looking for verification that the plan actually has a right of recovery in the first place. The default will be state law, though. If you obtain the documents, verify the plan has a right of reimbursement, with a fully insured ERISA plan, you're still looking at state law to guide the negotiation strategy. So the big takeaways are, don't stop at ERISA. Find out if it's self-funded or fully insured. Get the plan documents to make sure they're actually allowed to recover. And lastly, use state law to guide your negotiation if it's a fully insured plan.
And what about other kinds of self-funded plans that are not ERISA? How do I go about handling those?
This is actually something that gets missed a lot. People usually think self-funded plans automatically fall under ERISA, but that's not always the case. There are actually two big types of self-funded plans that aren't going to be governed by ERISA. The first is government plans. So these are health plans for city, county, state, or federal employees. And the second is church plans. These are plans that are tied to religious groups or are church-affiliated employers. Those types of plans are going to be exempt from ERISA. So even though these plans can be self-funded, meaning the employer is the one actually paying the medical claims, ERISA rules wouldn't apply. So that means the plans don't get the ERISA preemption, and instead you're going to look to state law to figure out if they can recover or subrogate. Still, for these plans, it is very important to get the plan documents. It all comes back to the plan documents. So just as you would with any ERISA plan, you're going to request plan documents on these types of plans. You need to see if there's actually recovery language in there. Once you have that, then you can use state law to kind of guide you through the negotiation process. Some states are going to limit or even block recovery altogether, and this can really work in your favor. So bottom line, just because the plan is self-funded doesn't mean ERISA applies. And if ERISA doesn't apply, state law is what you're going to look to. And lastly, always get the documents first so that you know exactly what you're working with.
We have reached the end of our Q&A presentation with our expert roundtable. These are just some of the questions that we hear on a regular basis through consults and through our interactions with our clients. So we thought we would package them all together. Hopefully you learned something. Maybe you already know all these answers, which is phenomenal, but hopefully you picked up something to apply in your practice. So here is our contact information. We, of course, want to partner with you and be your lien resolution partner. So give us a call or send us more cases and let's see what we can do together. Thank you for joining us.
Hi, this is Jason Lazarus, founder of Synergy. Thank you for attending today's Synergy Insight presentation. Before we conclude, I wanted to take a moment to tell you a little bit about our team pictured on your screen right now. Synergy is a mission-focused organization dedicated to improving the lives of the injured as well as their families, and freeing trial lawyers and their firms to focus on what they do best. We all care about this mission deeply. I am so proud of our incredible team that works tirelessly each day to get the best possible results for you and your clients. It's why Synergy has been consistently recognized as one of the fastest growing companies in the US. Contact us today to find out about forming a strategic partnership with Synergy that will transform the efficiency and profitability of your practice.